So welcome everyone to this, I guess it's the second event of the Constitutional Law Center in this academic year, and what has become one of our most popular annual affairs, which is a review of last year's Supreme Court term, and more importantly, discussion and review, a preview of coming attractions. And as we have three of the nation's great appellate lawyers with us tonight, and I'm going to give very brief introductions, get out of the way, and let them talk. So beginning on the left, Erin Murphy, who is a partner in
It's now Clement Murphy.
Clement
I move
Murphy,
around a lot. It's okay.
Clement Murphy, and she's done, I don't know how many arguments in various courts, including the Supreme Court, and is one of the great advocates. And Easha Anand, who is our own co-director or co-teacher or whatever the title is in the Supreme Court Clinic, and Michael Mongan, who is the Solicitor General of the state of California, which I think is one of the best law jobs in the whole country. So please join me in welcoming them, and I'm going to get out of the way.
Oh, am I just kicking things off? Oh, okay. All right, well, happy to do that. So thanks everybody for coming. So what we thought we'd do is start with a little bit of just an overview, just some kind of high-level thoughts about last term and where the court is, and then dive into some of the cases the big cases from last term, as well as a few of the big ones that we're anticipating for this term. So I'll kick it off with a couple of my own observations about where the court is and what we know and what we don't know about it. I think the big question ever since we've had the most recent composition of the court, which frankly we've only had the most recent composition of the court for a year, but even just if you go back a couple of years, is kind of how conservative is this court? We clearly have a 6-3 majority of this court that leans conservative. And a couple terms ago, I think there were a lot of predictions after the Dobbs case of the court being a particularly aggressively conservative court. And there were a lot of expectations coming into last term from both kind of people who were excitedly anticipating it and people who were very unhappily anticipating what they thought were going to be some kind of uniformly big conservative decisions from the Supreme Court last term. As you'll hear as we talk through some of the cases tonight, that really just didn't prove to be the case. We certainly had some big cases that were 6-3 decisions that line up in sort of the traditional conservative liberal alignment, but we had some really big cases that had been predicted to come that way, or at least some thought they would, that did not come out 6-3 conservative, and in fact came out the other direction in one 6-3 and in one 5-4. And you have some other cases too when you just look at the broader universe of what the court's doing that I think make the narrative more complicated. There's certainly some aspects in which certain justices are kind of much more, as I would think about it, I think of it kind of dogmatic, doctrinal. Some justices we're still seeing have a more pragmatic streak, are thinking maybe more about the court as an institution. And one of the other big questions is, as we look at kind of the Dobbs term, where we saw the court overrule big precedents, take pretty big steps, as compared to this past term, where we saw the court actually decline basically every opportunity it had to outright overrule precedent. The question arises, which one is the court? Is the Dobbs kind of term the anomaly, or is this past term a reaction to Dobbs? How much is the court really the more aggressive 6-3, or really the court that has a lot more fluidity on it? And frankly, at this point, we just don't have probably enough data to tell us. So that's certainly something I'll be paying attention to over the coming term with some of the cases, and especially because right now on the court's docket, there's some really important cases, but there's fewer cases than often going into a term that are like really big hot button ones where it's, where there's sort of a predictable alignment where we expect the court to be. I think there's a lot more cases, even in the big ones right now, where I would not be surprised to see some unusual lineups, or certainly at least not completely predictable ones. The one other observation I'll offer is, I think an open question after the 2 terms ago was, what is the role of the Chief Justice on what we've thought of for years as the Roberts Court? Many saw the Dobbs decision as kind of the ultimate kind of loss for the chief, and the idea of the court being minimalist, since he couldn't kind of bring anybody along with his position, that the court could rule for the state but didn't need to take the step of overruling Roe v. Wade. That too is something, to the extent there was sort of a view of this shows the chief has really lost kind of control and influence on this court. I think that's another narrative that's really challenged by the past term, as you'll hear tonight when we talk about the biggest cases of the term. What I think of as 4 of the 5 biggest cases were written by the Chief Justice, 2 of them going the conservative way and 2 of them going the more liberal way. So you see the Chief Justice continuing to be a huge influence on the court and bringing together different constituencies of the court to get to various results, and certainly keeping plenty of big cases for himself, as is his prerogative as the Chief Justice. But I'll stop there and let you guys offer some thoughts as well.
Sure. Well, thanks, and thanks so much to the Constitutional Law Center for inviting me. It's a pleasure to be back at the law school, and a real honor to be on the same panel as Erin and Easha. Just a quick housekeeping item. I should note that the views I express today are not necessarily those of the California Department of Justice. And with that out of the way, one thing that I will be keeping a close watch on this term is the emergency applications docket. This has gotten quite a bit of attention over the last few years. It seems like Steve Vladeck and the shadow docket have become household names, at least in my household, where my family wondered where I was for large parts of 2020 and 2021. And I think it seems like there's a potential for the emergency docket to be pretty active this term. There's lots of contentious things going on in the country, and we're heading into a federal election cycle, which often generates emergency applications. And there are also some high-profile criminal prosecutions on the horizon, and I wouldn't be shocked if some of those led to emergency applications as well. Looking back to the last term, it seemed like the court perhaps moderated itself a little bit on the emergency applications docket. There were fewer sort of high-profile, controversial grants of extraordinary relief, at least from where I sit. And unless I missed it, I don't think that there was any emergency case where there was a reasoned opinion from the court. There were opinions, separate opinions, dissents and the like, but the court sort of stuck to the traditional one-line orders, generally in granting and denying relief. I'm going to be very curious to see if those trends hold up this term, especially as the court might confront some big, very high-profile emergency applications. Another trend, and maybe a related one, is that the court has seemed somewhat more willing of late to use the shadow docket as a tool for sort of skipping past the cert stage and going directly to merits briefing and argument. You saw this last term in the student loan forgiveness case, in the immigration enforcement priorities case. You saw it over the summer in the opioid bankruptcy case, often at the behest of the federal government. And that approach can yield some efficiencies, allow the court to get more quickly to a conventional reasoned decision following briefing and argument. I'll be interested to see if the court looks to that more often in this upcoming term. And then last, I'll be interested to see the role that Justice Barrett plays. I think you get the sense that Justice Barrett is playing a more prominent role inside the court on some of these emergency application issues. She wrote a concurrence a few years back sharing her view that the court should be very wary of granting extraordinary relief unless there's a good prospect that it'll be granting cert eventually in that case. It appears that she joined the majority that voted in favor of a stay in the Mifepristone case because she came in for a sort of subtle dig in Justice Alito's dissent. And I have a sense that her views may be particularly influential with the Chief Justice and Justice Kavanaugh. And of course, those three justices are going to be critical for any emergency application going forward. So lots to watch on the shadow docket in the term ahead, and I'll turn it over to Easha.
Great. Well, thanks, Michael, and thank you so much to the Constitutional Law Center and to Michael and his team for having me here. Echoing what Mike said, that it's a total honor to be up here with the two of you. I thought I'd use my kind of broad, big picture remarks to talk a little bit about the influence of our newest justice, Justice Jackson, who just finished her first term on the court. So the first kind of high-level thing to highlight is she really did make a mark, right? She spoke more than any justice on the court, which is a remarkable feat for a junior justice. And, it's impossible to know kind of how her voice plays out behind the scenes, but I think you can draw a fairly direct line from at least some of her questions to actual opinions. So, I'm thinking of, we'll talk a little bit about the affirmative action cases. She poses a series of hypotheticals at oral argument about how colleges are going to handle essay questions. And I think you can draw a pretty direct line from the kinds of concerns she's articulating to the kind of final paragraph of the Chief Justice's opinion, where he kind of carves out essay questions and says that's a separate question, and colleges actually have a lot of leeway. Adam Liptak noted that it took the Chief 15 years before he wrote a solo dissent. Justice Jackson's in 3 in her first term alone, and that's not even counting all of her writings on the shadow docket, right? So really kind of unafraid to be a big voice even in her first term. So what is she saying? I think here too, she's occupying a somewhat unique position on the court. So I'll highlight kind of 3 strands that I think about with Justice Jackson. The first is this sort of burgeoning libertarian alliance between Justice Jackson and Justice Gorsuch. So you see in 2 cases this term, the pair of them writing and no one else joining them, kind of out on this limb. So one case is a case about the Bank Secrecy Act. And Justice Gorsuch and Justice Jackson are kind of the only 2 justices who would say that the rule of lenity, which is a rule in the criminal context that says kind of ambiguity in statutes favors the defendant, that this applies to punitive statutes that are not necessarily criminal. There's another case called Tyler. It's an excessive fines clause, it's a takings clause case. But Justices Gorsuch and Barrett say, you know what, I think actually the 8th Amendment's excessive fines clause has something to say here as well. So you see these 2 kind of uniquely sort of skeptical of the government's power to wield punitive sanctions and uniquely willing to say that a lot of the protections we kind of previously reserved for things labeled quote-unquote criminal should actually apply more broadly. So that's kind of the first way in which I think she occupies a kind of unique place on the court. The second is Justice Jackson, I think, has an approach to statutory interpretation I haven't seen before. So she's neither the kind of Justice Kagan, we're all textualists now mold, nor is she sort of the Justice Breyer, like text schmext, that's like a vague starting point. She sort of threads this sort of interesting middle ground where she kind of seems to be saying, look, the weight we should put on the words of the statute turns in part on how they got there. So she writes a dissent in this habeas case where she says, basically, look, the majority is putting this huge amount of weight on 3 words. But it turns out this part of the statute was passed in the wake of the Oklahoma City bombing. It was rushed and emotionally charged. It's pretty obvious, actually, that Congress just copy-pasted accidentally, copy-pasted rules for state convictions into the federal context without thinking too hard about it. And so unlike statutes where we're interpreting a key word that was haggled over and was the product of kind of legislative compromise, maybe our kind of plain language tools don't have quite as much force here. And I'm not really sure I've seen someone articulate a vision of statutory interpretation that looks quite like that says sometimes, yes, text is text and all you want to look at is the plain meaning of the words, but sometimes other interpretive tools are useful because actually the way that the text got there wasn't the sort of product of reasoned decision making. So I think that's interesting. And then the final thing I'll say is I think Justice Jackson is probably most vocal about her focus on the kind of second founding and kind of taking some of her colleagues who believe in originalism to task for, in her mind, overlooking some of the data from that time. So we saw this a lot in the kind of affirmative action and voting rights oral arguments. She brings up quite frequently the kind of evidence of race-conscious remedies in the aftermath of the Civil War. She sort of asks, she tells one of the advocates, like, that Congress, the one contemporary with the 14th Amendment, I don't think they believed in race neutrality or race blindness. So I think it's another way in which she's sort of a unique voice on the court. So we'll see, right? I mean, she's the most junior justice. She's been on the court a single term. She doesn't get the kind of big writing assignments yet. But I'm sort of excited to see how these and kind of other strands of her jurisprudence develop as we go forward.
So I think we're now going to shift to the portion of our event where we review some of the major cases from the 2022 term. And as the state government employee on the panel, I've been charged with discussing 4 cases that will affect the role of the states in our federal system going forward. I'm going to start with National Pork Producers Council against Ross. This is a case that I'm particularly fond of, not just because I care about the humane treatment of animals and also really love to eat pork, but also because of the significance for the states going forward. So this was a Dormant Commerce Clause challenge to California's Proposition 12, which prohibited the in-state sale of certain pork products defined based on how they were produced at the farm. And as it happens, California does not have a lot of pig farmers, so most of the pork that we eat is produced out of state. Now, if you read the major press coverage on this, this sort of TLDR on the court's decision was that California prevailed, but the court was hopelessly fractured on the rationale. And I think there was actually quite a bit more consensus than that. So the main challenge in this case by the plaintiffs was under what they called the extraterritoriality doctrine of the Dormant Commerce Clause. And they pointed to 3 earlier cases that had suggested that if a state law has the practical effect of controlling out-of-state commercial transactions, then it's per se invalid. We took a very different and narrower reading of that precedent. We thought that it was limited to situations where states were trying to control the prices paid in out-of-state transactions. And on that point, the court unanimously agreed with our position, which is a big deal for the states because we've been hit with a huge number of Dormant Commerce Clause challenges over the years to a wide array of policies that try to invoke that broader conception of those cases. Now, the second issue in the case was the claim that this fails the balancing test in Pike against Bruce Church, which balances the burdens a law imposes on interstate commerce against the purported in-state benefits. And here the court was divided in its rationale. There were not 5 votes for a particular rationale as to why the complaint had failed to state a claim. We saw 3 justices, Gorsuch, Thomas, and Barrett, who were of the view that courts just aren't really capable of balancing the types of benefits and burdens at issue in this case, health and safety benefits against economic burdens, because they're incommensurable. We saw 4 justices, Gorsuch, Thomas, Sotomayor, and Kagan, who said the plaintiffs here failed to make the required threshold showing that this law substantially burdened interstate commerce. Their allegations established that it might increase their costs or change their methods of operation, but that's not enough under Pike. Even here, though, we saw some consensus, and there was a majority of the court that joined part of Justice Gorsuch's opinion that said, as a general matter, Pike claims are going to have to fall into one of 2 heartland categories. One is claims that challenge a facially neutral statute but allege that there is some hidden, lurking discrimination against interstate commerce. The other is laws that substantially burden instrumentalities of interstate transportation, so think trucks and trains. And I think that ultimately this case does leave some things to be litigated in the district court and work for the lower courts to do, but a majority of the court is making quite clear that it views the Dormant Commerce Clause, or Pike, as quite narrow, and I think it'll be pretty tough for plaintiffs to move forward with Pike claims if they're not within one of those 2 heartland categories. So from pigs, I'm going to move on to water and talk about Sackett against EPA. This is a case about the Clean Water Act, which prohibits the discharge of any pollutant into navigable waters without a permit, and it defines navigable waters to mean the waters of the United States, including the territorial seas. So the question was, well, what does that mean, and to what extent does it cover wetlands? And the court had tried to answer that set of questions before in 2006 in Rapanos against United States, and it splintered fairly badly. So there was a four-justice plurality in Rapanos led by Justice Scalia, who said the act covers only relatively permanent bodies of water, oceans, rivers, lakes, and the like, and that wetlands are only covered if they have a continuous surface connection to such a body of water. Justice Kennedy disagreed. He advocated for a broader significant nexus test. Does a wetland have a significant nexus with a traditional navigable water? And the four liberals at the time dissented and argued for a still broader test. So fast forward 17 years, and in Sackett, Justice Alito leads a majority of the court to embrace that rule from the Rapanos plurality. And the majority opinion is focused on text and history, but in fairness, there's quite a bit of policy interwoven into its discussion. Lots of concerns about the unfairness for businesses and homeowners of a broader significant nexus test, and emphasis on the steep civil and criminal penalties under the act. There's one tricky aspect of the textual analysis for the majority, which is that the act has a provision that even the majority reads as directing that wetlands do sometimes fall within the act if they are, quote, adjacent to navigable waters. And the majority does some tap dancing and sort of says, well, adjacent in this context means it has a continuous surface connection. So to respond to the majority, the liberal wing of the court turns to its customary environmental champion, Justice Kavanaugh. And Justice Kavanaugh says, as a textual matter, you're rewriting the statute to say adjoining instead of adjacent. My neighbor's house is adjacent to mine, even though there's a fence or an alley between the two. And in the same way, a wetland can be adjacent to a covered water, even if there's a dike or a levee or a beach dune between them. And he notes that the practical effect of this is to take a lot of wetlands that administrations past have uniformly thought were covered and suddenly make them uncovered, even though they can have a significant effect in terms of flood control and water quality on covered waters of the United States. So I think a few takeaways here. I mean, one is obviously just another example of the implications of a 6-3 court. Even with a powerful opinion from Justice Kavanaugh, the liberals don't have the votes for a majority here. It's also very interesting where the liberals ended up in this case, because they joined Justice Kavanaugh's concurrence in the judgment in full, and that opinion rejected Justice Kennedy's significant nexus test and said it was atextual and too broad. Recall that the liberals 17 years ago had criticized that same test as being too narrow. As a practical matter, as Justice Kavanaugh notes, this leaves a lot of wetlands that are no longer subject to federal regulation under the Clean Water Act. And so the focus will really shift to the states here. And the question is, will the states step up and fill that regulatory void, and in what way? Next up, I'll turn to Moore against Harper, which of course addressed and rejected the independent state legislature theory. This case arose out of a state court partisan gerrymander challenge under the state constitution in North Carolina to a legislatively enacted congressional map. And it had an extremely complicated procedural history, which gave rise to a fascinating jurisdictional question that I'm going to skip over in the interests of time. But on the merits, the theory advanced by the petitioners and ultimately embraced by Justice Thomas and Justice Gorsuch goes like this. The power to regulate congressional elections is a federal power. It's delegated in the Elections Clause. The Elections Clause says that those regulations of congressional elections shall be prescribed in each state by the legislature thereof. And when it says legislature, it means just that, the representative body that makes the laws of the state. And the legislature has independent and exclusive authority to exercise that power in this context. It's not subject to state judicial review for compliance with the state constitution. Here, this is one of the cases where the Chief Justice wrote for the majority, for a 6-justice majority, and made relatively quick work of this theory. He explained that the basic principle, going back to before the founding, is that state laws are subject to review by state courts applying state constitutions. And nothing in the Elections Clause carves out an exception as a textual matter. And if you look to historical practice and Supreme Court precedent, that confirms that state legislation in this context is subject to state constitutional constraints. Now, this is obviously an important case in terms of shutting the door, or mostly shutting the door, on the independent state legislature theory going into a federal election. At the same time, the majority does leave the door open to potential claims in this area. And the final part of the Chief's opinion emphasizes that federal courts will consider claims that state courts have, quote, so exceeded the bounds of ordinary judicial review as to unconstitutionally intrude upon the role reserved to the state legislatures. And Justice Thomas, writing in dissent, says, what does that mean? And that sort of vague language is going to suck the federal courts into a lot of nasty, last-minute, contentious election disputes where we are policing the state court's application of state law. And wherever you are on the sort of doctrinal or historical questions here, it seems to me that that observation is a fairly compelling one, and my expectation would be that we are going to see more of this litigation, probably sooner rather than later, in the federal courts. And then last, I'll turn to the student loan forgiveness case, Biden against Nebraska. The Biden administration's student loan forgiveness policy invoked a 2003 statute, the HEROES Act, which provided that in a national emergency, the Secretary of Education can, quote, waive or modify certain legal provisions that apply to federal student loan programs in order to alleviate the impact on affected borrowers. And the Biden policy was fairly broad in terms of the amount of loan forgiveness and how many people were eligible for it. And here the court divided on the familiar 6-3 lines on both standing and the merits, with, again, the chief writing for the majority. On standing, Nebraska and the other state plaintiffs had offered a sort of buffet of theories to the court, and the majority found standing based on a nonprofit government corporation in Missouri that services student loans and stood to lose millions of dollars if this policy went forward. Now, given where I sit, I'm always happy when the court embraces a theory of state standing. But I will note that Justice Kagan has some sharp words in dissent about this particular entity, and notes that it has, under state law, a separate legal status, that its financial losses would not be passed along to the state, and on that basis thinks that it should not be a basis for state standing. Turning to the merits, the majority says, well, this statutory question isn't hard at all, and reads the 2003 statute to allow sort of modest adjustments and additions to existing provisions, but not sweeping loan forgiveness policies. As you work your way through the majority opinion, though, it does seem clear that the biggest problem from the majority's standpoint is that this is just way too big in their view. It's more than $400 billion. 95% of federal student loan borrowers are eligible. And the chief eventually invokes the major questions doctrine and says that if there were any doubt, that doctrine would provide that Congress just needs to speak much more clearly to authorize a policy of this magnitude. Justice Kagan's dissent is fairly pointed. She thinks this is an easy statutory interpretation question too, going the other way, and that this is exactly the type of thing that the Secretary is authorized to do in the event of a national emergency. And then she turns to a real broadside on the major questions doctrine and accuses the majority of inventing the doctrine as a tool to negate broad congressional delegations that they don't like. And I think that in this debate between the majority and the dissent, there may be some harbingers of things to come in a case we'll talk about a little bit later in Loper Bright. Justice Kagan talks at some length about how she thinks there are advantages to broad congressional delegations and to Congress not having to act micro-specifically. And it's clear that many members of the court are very comfortable requiring much more detailed congressional legislation, at least for particular issues and policies. So I will turn it over to Easha.
I think I'm up next. So I thought I'd use my recap time first to talk about a pair of cases that kind of fit in with the story Erin told at the outset of this sort of aggressive conservative court, maybe pulling back a little bit from the perception from last term, and maybe amplify a little bit Mike's story about Moore. And then I'll talk about the one sort of big, overruling case from this term, the affirmative action case. So the pair of cases I want to focus on for that kind of first story are Halen versus Burkeen, which is a case about the constitutionality of the Indian Child Welfare Act, and Allen versus Milligan, which is like a Voting Rights Act case. And the story of these cases sort of have the same beats as the story that Mike told a little bit about Moore, right? Certs granted, and people who are sympathetic to respondents are really, really anxious. The opinions come out, and everyone breathes a little bit of a sigh of relief. But then there's a sort of niggling anxiety, even after that sigh of relief, if you're sympathetic to respondents, based on what the court said and the fact that some of these cases were even on the table. So let's start with the first point, right? So certs granted, people who are sympathetic to respondents are really worried about just how radically the Supreme Court might reshape the existing legal landscape. Halen versus Burkeen is about the Indian Child Welfare Act, which is a statute passed after kind of generations of state and federal government destruction of Indian families through forced boarding schools, assimilation camps, sometimes just straight up kidnapping. And so to try to kind of preserve the integrity of Indian families, Congress passes the statute that requires states to do everything in their power to keep Indian children with their birth families, a couple of other options, or failing any of those, with other Indian families. That's sort of the locus of the piece of the challenge I want to talk about. So the Burkeens come to the Supreme Court with a set of challenges to this law, most notably with an Equal Protection Clause challenge. They say favoring placement with other Indian families would be no different from saying white children must be placed with other white families, right? This is a racial classification and should be subjected to the kind of scrutiny we reserve for racial classifications. Now, agreeing with that challenge would have really reshaped the United States' relationship with tribal nations. That is, treating Indian as a racial classification rather than a political one would have gutted huge swaths of the United States Code. And so that's the sort of alarm bell, right? I was alluding to the first beat of the story, cert is granted and there's alarm bells. Similar story with the other case I want to talk about, Allen versus Milligan. This is a Voting Rights Act case. Section 2 of that act bars election practices that result in a denial or abridgment of the right to vote based on race. And there's a kind of long-standing framework called the Jingles Framework that governs how you look at redistricting, right, congressional or other political race map drawing in light of that statute. So in this case, Alabama passes a new map that, on the challengers telling, packs black voters into a single district in a part of the black belt and splits up the rest of the black belt into a bunch of other districts so that the end result is black voters constitute more than 25% of Alabama voters, but they only get a single district where they're the majority. And at the state stage, so this case comes up, it goes to a 3-judge panel. To the extent it's relevant, 2 of those judges are Trump appointees, and they say this map is no good, it violates the Jingles Framework. And at the state stage at the Supreme Court, a majority of the Supreme Court says, we're going to actually put this decision on hold and we're going to reinstate Alabama's map for the upcoming election. And even the chief, who sides with the kind of liberal justices and saying, I don't think we should stay this, even he says, I'm not sure we're doing Section 2 cases correctly. It says, it is fair to say that Jingles and its progeny, that's the kind of governing framework, have engendered considerable disagreement and uncertainty. So it's a little opaque, but it seems to be a reference to the state's argument at this stage that, historically, the way that you did these redistricting cases was plaintiffs kind of came forward with a plan that they said, look, here's a plan that draws more majority-minority districts and fits in with these various other districting criteria. And we know there's a history of kind of polarized voting in this state and other things from which we can infer racial animus. And the state had come in and said, when you come into court, you should not be able to, plaintiffs, present a map in which you've taken account of race to draw the number of majority-minority districts. You should basically run a computer simulation, however many thousands of times, and tell it not to consider race, see what your kind of median map looks like, and that's the baseline on which we should be arguing. So that's the first part of the story. And so again, this is a sort of, this is a grant where people sort of think, oh no, right? If you're sympathetic to the position of the plaintiffs in this case, of the challengers in this case, this seems to be taking really direct aim at the way that we've done redistricting for a long time. And a majority of the court at the stay stage saying, I think that there's, Alabama's map is not, at least not so bad that it should be put on hold for this election cycle, and the chief saying, I'm curious about Alabama's theory. So that's kind of beat number one. Beat number two of this story, as Erin kind of alluded to up front, is in each of these three cases, the court kind of pulls back. It doesn't wind up doing the thing that people feared it would do. So in Burkine, the court says, sort of dodges the question, says no one in this case has standing to raise that Equal Protection Clause question, in part because ICWA, this statute, operates on state officials, so they haven't named the right defendants. And in Allen versus Milligan, the court applies the Jingles framework and says, does it sort of the way it's been done for 2 generations, and says, lower court decision striking down Alabama's map, that was totally correct. Before we sort of say, are too sanguine about this outcome, I think it's worth noting kind of how wide the Overton window has opened when it comes to things like stare decisis and precedent, that people were even worried about this, right? To side with the challengers to the Indian Child Welfare Act on this Equal Protection Clause theory, the court would basically have to turn its back on a century of precedent. As the chief put the point in Allen, the state's argument would have required a change to a framework that has been the core of our Section 2 jurisprudence for nearly 40 years. So that's one flag. It's just the fact that people thought the court was going to take this additional step as a sort of sign of how our kind of norms around the court have been reset a little bit. And then the other flag is that Justice Kavanaugh's role in both of these cases is sort of unique. He votes with the majority to do the kind of the thing that's sort of pulling back from the kind of most aggressive reshaping of the legal landscape. But in each case, he's sort of writes separately. So he says in Burkine, he basically says, I think the Equal Protection Clause issues are very serious. I think someone should bring us a case that really tees this up. And in Allen, same thing. He sort of says, even if Congress once had the power to authorize race-based redistricting, the authority to conduct race-based redistricting cannot extend indefinitely into the future. He says, Alabama didn't raise that argument here, but that argument has some force. So in other words, sort of watch this space when it comes to both of these cases. For the dogs that didn't bark this term, but as in the Moore case, a bunch of justices are sort of signaling or including language to suggest that this is the sort of last we're going to hear on these questions. So the other case I want to discuss, and this is sort of the counter to the no big overrulings this term, is the Students for Fair Admissions versus Harvard case. And I suspect many of you in the audience kind of know a little bit about the case in the bottom line. So I'll spend my time talking about kind of 2 notable features of the Chief Justice's opinion for the court, striking down the affirmative action programs at Harvard and UNC. So the first is a point about stare decisis. So formally, right, search the opinion high and low, there's no indication that it's overturning prior precedent. But the Chief's doctrinal analysis rests on 3 moves, all of which are a little bit inconsistent, perhaps a lot of bit inconsistent, with the case law that had existed before this case. So first he says, these affirmative action programs fail what's called strict scrutiny. Strict scrutiny is the idea that when you are engaging in any kind of race-based classification, you have to show a compelling interest. And so prior cases that said enhancing diversity is a compelling interest. And you have to show that it's narrowly tailored. That is, the way that you're doing it takes race into account the very least bit possible to achieve that compelling interest. And so prior cases that said, look, if you're not, as long as you're not relying on a quota system, as long as you're acting holistically, that's enough for narrow tailing. The chief says, the second reason he relies on, he says, this program uses race as a stereotype or a negative. College admissions are zero-sum, so a plus for one person is a minus for another. And the third doctrinal move he makes is he says, the case law makes clear there must be an endpoint to this sort of race-based consideration. And this is drawn largely from a separate writing by Justice O'Connor in a case called Grutter, where she says, it has been 25 years since Justice Powell first approved affirmative action. We expect that 25 years from now, the use of racial preferences will no longer be necessary. Well, that always sounded to me like just a little bit of a rhetorical flourish, right? Sort of an ode to the progress that Black citizens have made and a hope for the future. But the chief says, it's like been almost 25 years, and Harvard and UNC didn't actually tell me any endpoint. So this is sort of another reason that these programs fail. So all well and good, except that Justice Sotomayor's dissent points out all of these things were true in past cases as well, right? So, and those are cases where the court upholds affirmative action programs. So the educational benefits of diversity, they were no more kind of measurable or quantifiable, 30, 40 years ago than they are today. College admissions, they were no less zero sum, right, 30 or 40 years ago than they are today. And colleges kind of articulated no firmer endpoint or sunset date in those old cases than they did today. And the chief doesn't really kind of meaningfully dispute any of that the kind of core premises he relies on in this case are fundamentally inconsistent with the kind of core premises that animated the prior cases. What he does say, though, to the extent he addresses stare decisis, he sort of says, look, there can't really be a meaningful reliance interest on those prior cases because we told you it was only going to be a 25-year thing or a temporary thing. So this doesn't sort of really invoke the heartland of stare decisis because you knew it was not a forever thing. And so if you relied on those cases, that was error. So that's the first point, is the sort of, I think, functional overruling of the cases that came before, whether or not the chief says so in name. The second thing I want to spend just a beat on before I pass it to Erin is something I alluded to in my opening remarks, is just the kind of money line in the chief's opinion, the line that's going to be the driver of all future litigation, which is where he sort of says, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But he says that sort of essay or discussion about the role that race played in an applicant's life, it cannot play a stealth role in undermining the rest of the opinion. So first of all, the line between giving special consideration to an application because of the applicant's race, not allowed, and giving special consideration to an application because the applicant faced hardship that is inextricably intertwined with race, allowed, is razor thin, right? The chief is essentially drawing this distinction that I think inevitably invites lots more litigation, however colleges and universities choose to frame their solicitation of an applicant's experience and how race affected his or her life. The second thing is, the thing that the chief rules out that this kind of line in his opinion doesn't salvage is that even if, when looking at an individual application, admissions officers can consider how race affected an individual's life, the opinion pretty clearly seems to say that admissions officers can't kind of do the back-end thing that they do where they look at the class as a whole, right? So every admissions process goes through, tries to pick out the best applicants, and then there's a sort of step back stage where they say, we got way too many oboe players, we have way too few drama kids, whatever the case may be. They sort of do the balancing around the edges because they're admitting a class, not just a series of excellent individuals. And I think the opinion pretty clearly rules out doing that with regard to looking at the racial composition of the class. And I don't take that sentence of the chief's opinion to salvage that. And then the third point I'll just make here is, there's a reason why we use objective proxies as some part of the admissions process, right? We use proxies that are radically over-inclusive or under-inclusive, and we know that they're not great, but we use them because we think that we don't ultimately want the decision to be entirely the kind of subjective position of an admissions officer. And by moving to a system that relies on a description of how race affected a candidate's life, I worry a little bit that we're moving to a system that first encourages gamesmanship, right, where savvy applicants will know how they ought to package the story of how race affected their life. And second, where whatever biases admissions officers have, right, and all of these perceptions of biases, whatever biases admissions officers have about how they think race affects someone's life, come into play in deciding which of those applications get special consideration. And so ironically, I kind of worry that in trying to root out stereotypes, the Supreme Court may actually be creating an admission system that doubles down on stereotypes. That is, I worry that only those students who are able to kind of package their race and lived experience in a way that's legible to admissions officers will get the kind of special consideration that the chief seems to say still exists. So there's so much more to say about each of these cases, but let me stop there and turn it over to Erin to talk about a couple of the other big cases from last term and transition us to the coming term.
Okay, but first I have to take a personal prerogative to just,
Yeah.
offer a brief comment on. I mean, I guess I just, I think what the chief was saying is not quite that complicated and not. I mean, I totally agree. There's going to be a lot of litigation in this area, but to me, the argument that was being rejected was the idea. So it's quite common for admissions officers to take into account other ways in which people overcame obstacles in their lives. To talk about, just personal things that happened to you, experiences, things like, being the first person in your family to go to college, overcoming, kind of coming from different areas. And I take the chief to be saying, it's not like you can't consider those kinds of individualized experiences just because race is part of them. It's not off the table in the sense of everybody else gets to talk about the hardships they've experienced in life, but you can't talk about the hardships you've experienced on the basis of race. All of that has always been part of individualized processes. And I think what he's getting at is the idea of, that's still okay, and it's still okay in the context of race. But what you can't do is think about it as, how do we ensure that people continue to get special consideration because of their race, rather than because of what we would think of as something that's not race-based, but rather demonstrating that you have certain experiences in life that lead someone to believe that you may be someone who'd be a good fit for a school, whether they're based on overcoming a hardship having to do with race, a hardship having to do with how you were raised, what educational background you had, whatever it may be. Now, of course, the devil is in the details of how schools go about doing that, and I do think this is going to mean that what we end up with is a lot of litigation that looks at schools and asks what really ends up happening. Do we end up seeing, sure, there are people who, whose essays have a real impact, and some of them have a real impact in the ways they talk about that race has impacted their life and their life experiences, or do we end up looking at things and seeing what I think the court felt like it was seeing in Harvard and North Carolina, which is virtually any time somebody talks about race in an essay, they end up getting special consideration. And that's where I think schools are going to get into trouble if it looks like, oh, we figured out like this is the code way to go about having exactly the same practices that we've always had. That's not going to fly, at least when it gets to the Supreme Court. But I do think what the court was trying to say is, we're not saying that you have to pretend like race never has anything to do with someone's life. We're just rejecting the idea that you should assume that it always is a defining feature in everybody's life.
So I'll respond really quickly, and then I'll let you kind of. The only thing I want to. So I think there's not so much daylight between what we're saying. I think you agree with me that that's going to invite a lot of litigation. That's a very
100%.
very fine distinction to draw. I guess the reason I think colleges are in a bind is that, to some extent, colleges have made the assumption, and maybe this is right or maybe this is not, that in most cases, race plays a very central role in a lot of people's lives. And so if that's true, then actually you'd expect the racial diversity of their classes not to look very different, right? Because at the point where you're looking at the essays, many of the applicants who you would have admitted previously, you'll be still admitting, because if colleges have been right all along that actually this sort of inextricably intertwined with your life, then the racial diversity shouldn't change very much. But the kind of Edward Bloom letter that comes out is sort of like, if your racial diversity doesn't change very much, we know you're stealth doing the same thing that you were doing before.
Yeah, and that's where it's going to matter. You're going to have to look and see what it is. I mean, it's going to be. I think it's not that it's impossible for schools to know which way they're coming about it. It's that it's not the easiest thing in the world to police which way schools are coming about it. And it may well be that, just as in the context, a lot of other contexts with race, like things dealing with election law, that sometimes you can demonstrate. It's not, part of the Allen versus Milligan decision. Sometimes things are not because of race, but race exists and you can't completely ignore it, which is a big part of what the court was saying in the redistricting context. But, on the flip side, I think if schools start from the view of the goal is to end up in the same place, that's what the court's going to view as a problem, because that's sort of the viewpoint that I think the court sees as problematic, is starting with the back end assumption of this is kind of where we should be in our diversity metrics, and we got to figure out a way to get there.
I see you have a note about Allen versus Milligan. Do you also want to?
No, we can have some more discussion as we go on. I got views about everything. So, but in the interest of time, I will spend a little bit of time. So I'm going to talk a little bit about the court's, loosely, I'll call it kind of the First Amendment, IP, social media docket from last year, and a little bit about how that transitions into some what we might see from the court this coming year. So I'll start with the 303 creative case, which was the case about Colorado's public accommodation law as applied to a woman who provides a custom website design business in which she wanted to provide custom websites for weddings, start providing them for weddings, but for her religious reasons was unwilling to provide the service to celebrate same-sex marriages. This is a case that, in a sense, was kind of a long time coming. Anybody who's come to this event for a while might have even heard me talk about the Masterpiece Cake Shop case a few years back when the court first confronted the same question, essentially, involving the same Colorado public accommodations law. The court had a different composition back then. It was when Justice Kennedy was still on the court. And at the time, that case concerned a custom cake maker who essentially had the same arguments as Lori Smith, the custom web designer here did. And it was really interesting if you go back to particularly that oral argument in that case and the way the court approached it. They struggled. The court took the case was litigated principally, while it was a religious objection, it was litigated principally as a free speech case, not as a free exercise religious rights case. So it really arrived to the court with the question having to be based on the idea that the cake maker was engaged in speech. And the court back then spent a lot of its time kind of struggling with the question of how do we decide which kinds of expressive activity are speech? Is the cake maker on the right side of the line? If we put the cake maker there, what do we do with like the florist and the table designer and all these different people? And that, I think, sort of tripped the court up a lot, and then I think Justice Kennedy was also just sort of struggling with the way to resolve the issue. So that case ended up kind of being resolved in an exceptionally narrow way that was very fact-specific and dealt with there being discrimination in the proceedings of that particular case. This case, in the intervening years, the court has had a lot of opportunities to return to this question. There were a bunch of petitions with a bunch of different folks out of Colorado and a couple of other states with similar laws, and the court declined a series of them over the years and then eventually took up this case. And I think there's a reason they took this case, and that reason largely kind of dictated where the court was going to end up in this case, which was ruling 6-3 in favor of Masterpiece Cake Shop. The case came to the court with stipulations that essentially resolved the question of whether it involved speech. It had been stipulated below both that a website is speech and that even though Ms. Smith is designing websites for her customers, that she herself is engaged in expressive activity when she works with them on those websites and puts out websites that are designed by her company. So basically, while there was plenty of discussion among the justices again this time around about what is speech and whether to think of things, what to think of as on the right side of the speech divide, I think this case actually really came down to the question of whether you view this as as compelling the speech of Ms. Smith or as doing something else. And for the majority, they relied heavily on the fact that it had been conceded below that this did involve Ms. Smith's speech. And at that point, what you have is essentially a state law that is saying you are compelled to embrace a message celebrating a same-sex marriage, a message that you don't believe in and that you have objections to. And the court really, when confronted with that square question of whether you can compel speech, and even in the context of public accommodation laws, the court has consistently in the past said no. You can apply public accommodation laws In lots of other contexts, sure, you can say that you have to let someone stay at the hotel, stay at the restaurant, serve people generally. But when the service you're providing or the activity in which you're engaging is speech, and the result would be to compel you to speak a message with which you disagree, that crosses the First Amendment line. And that's what the majority of the court held here. And frankly, I don't really read the dissent to take issue kind of with that as a general principle, with the idea that, generally we do think there's a First Amendment problem with compelling people to speak messages with which they disagree. In fact, you could historically argue that that's kind of an even stronger strain of our First Amendment protections than the ability to speak messages you want to speak. But there was instead probably really a lot of the debate here, you could say, centered around thinking about the nature of this business, whether it really was, whether she really was engaged in speech, notwithstanding those stipulations, whether you should think of it that way or think of it as providing a service that is really facilitating the speech of others. So case has been, was a long time coming. It ended up getting resolved, but again, as in Masterpiece Cake Shop, presented and resolved only on the question of free speech, and only in a context where the court didn't really confront a lot of the issues about what is and isn't speech. So I do think while we've got kind of a big picture resolution of an issue that's been litigated for quite some years now, there's actually still a lot of litigation probably to come with these laws. For one, there's certainly going to be cases about whether things are or are not speech. And for another, in the cases where courts conclude that something isn't speech, eventually you have to confront the separate arguments about whether these kind of laws violate the free exercise clause as applied to somebody who has a religious objection to the particular activity that they're being compelled to engage in. The court went out of its way to not address that question here. It removed that from the question that was presented to the court in the cert petition and left it for another day. I don't think that's a can they're going to be able to kick down the road forever, but they've at least probably bought themselves a few years on that one. So one of the other fun cases that the court decided this term that really was ended up being a little less disputed among all the justices and produced more unanimity than most of the cases that we've talked about today. Some of you may have followed the case about Andy Warhol, the Andy Warhol estate case, Andy Warhol versus Goldstein, which involved a dispute under the Copyright Act about the fair use doctrine. So the copyright laws generally provide copyright protection for the works, the creative works that someone creates, but that is subject to a doctrine known and statutorily codified as the fair use doctrine, which is a doctrine that allows for the use of works created by others in certain circumstances when certain factors are satisfied. And this case concerned a particular one of those factors. It is a really interesting and fact pattern to the case. So it arises out of a very well-known photographer of rock stars who had years ago, back in the early 80s, when Prince was first becoming famous, did a series of photographs for Prince, one of which was on the cover of a magazine back in the day. And a few years later, her photographs were purchased by Vanity Fair, yes, for purposes of they wanted to purchase her photographs and let an artist kind of work with them to create a cover for one of their own magazines. And the artist ended up being Andy Warhol, who used his kind of classic silkscreen method to take the photograph and alter it and create a new cover for Vanity Fair. This all happened back in the 80s. At the time, they bought a license from her to use the photograph, but it was a license that allowed them to use it only once for that specific purpose. Unbeknownst to her, Andy Warhol kind of had the photos and made a whole series of silk screens, and upon Prince's death, one of them that she'd never seen before appeared on a new cover of Vanity Fair celebrating his life, and at that point, she brought suit for copyright infringement. And the case basically involved the question of how you think about this first factor under the fair use doctrine that deals with the particular kind of purpose and nature of the use of the artist's work that was unlicensed. And the court below had really focused on the idea that Andy Warhol did something transformative in the sense that when you looked at his silk screen, you saw something different. You saw kind of an iconic Prince versus seeing kind of a young and emerging Prince and a little bit different version of him back in the original photograph, and viewed it through that lens of, you're getting a different message, and Andy Warhol wanted to convey a different message. And on the flip side, the photographer's view was, look, like, message or not, you took my photo and you're using it for exactly the same purpose. I'm still selling my photos. She had sold one of her own photos to another magazine to be on the cover when Prince died. You're taking my work. You're basically using it to just create something similar and compete with me in the very same market to be out there providing depictions of this artist. The court had a lot of fun with this case, and it was really early on in the term when people were very like, is the court just going to, they all just like hate each other after Dobbs, and they're not speaking to each other, and it's just an awful, and then they show up. I mean, it was one of the first, it was sometime in the first sitting, and they just were like genuinely enjoying themselves. We learned during the argument that Justice Thomas was once a fan of Prince, but apparently no longer is a fan of Prince. There was just, it was like they were just really, really into it, and people really said it. I wasn't in the courtroom, I did read the transcript, but where they're like, it was fun, and fun to see the justices engaging and having a good time, with an interesting legal issue that was a little bit less contentious in the sense of some of the other ones that they've dealt with. They ended up resolving the case 7-2 on a very, pretty narrow ground, saying that that the Second Circuit had been wrong to focus on that things through sort of the subjective lens of what the artist means to convey in transforming the work, and instead put a lot more focus on the notion that Andy Warhol was still using the work in the same way and competing in the same commercial way, but at the same time, they didn't even decide if it was copyright infringement, and they made clear that it might have been different if they were hanging the Warhols in a museum instead of putting them on a magazine. So it's a relatively narrow opinion. But the other thing I will note, it produced a pretty odd bedfellows dissent. I'm not sure if there'd been a dissent before. It was written by Justice Kagan and joined by the Chief Justice, just the two of them. And I can tell you, I have seen the Chief Justice talk about this in a speech. I have seen Justice Kagan talk about this in a speech. I have heard lots of people say they both talk about it, even not in speeches, all the time. So they both really love this case and love that they had this opinion together, and seem to have had quite a bit of fun with it. So the last thing then I'm going to talk about is a couple of cases, social media cases, and cases that didn't come about, and cases that are going to materialize for next term. Last year, we thought it was going to be a big term for social media. Some of you may remember that the court granted a case about the meaning of Section 230 of the Communications Decency Act, which of course has been a huge issue politically and hotly debated by the courts. The case went all the way to argument and produced, a great deal of interest, amicus briefs all over the place. The court struggled a lot at argument. There was an exchange in which Justice Kagan talked about being very uncomfortable that, sort of the court, what does the court know about the internet? Are they going to break the internet if they change the rules at this point? And ultimately, the court ended up not resolving that question at all, because they, in a companion case called Tomna versus Twitter, just decided that the particular claims that had been brought in that case were not viable claims under the statute that they'd been brought under, the Anti-Terrorism Act. And so the 230 ultimately materialized into nothing last term. But the court is on track to have social media right back front and center on its docket this coming term. On the court's first orders list of the term last week, the court granted cert in a couple of cases in which I'm involved, involving the party NetChoice, which basically is a trade group representing the social media companies. These are the cases involving laws that Texas and Florida passed a couple years ago that essentially are laws that seek to regulate the content on social media services. They impose restrictions on the ability of a social media service to remove particular content for particular reasons, to prioritize or deprioritize content for particular reasons. Essentially, they seek to exercise some degree of state control over what social media platforms can do with the third-party content that they don't want on their site or don't want to feature prominently on their site. These cases have been litigated up to the Supreme Court, and the Florida law was held unconstitutional, while the Texas law was held constitutional. So there's been a clear circuit split on this for a year now, and the court sat on those cases last year while it was going through the whole 230 exercise, but ultimately it just granted review of them. So we should have some really interesting arguments this year about the First Amendment rights of social media companies, about how you think about the role of the social media platforms vis-a-vis the third-party speech that they host. I'm sure there'll be some discussion of whether social media platforms are akin to common carriers. So stay tuned. Social media will be very front and center on the court's docket again this term.
So I will try to zoom through two cases and make sure that we leave time for some questions before we're scheduled to wrap at 6:30. One is one that I know Erin and I are both going to be watching with great interest, United States against Rahimi, which is the first Second Amendment merits case since the Blockbuster decision in Bruin last year. The Fifth Circuit applied Bruin's text, history, and tradition framework to a federal statute which prohibits the possession of firearms by people subject to certain domestic violence restraining orders, and held that it was facially unconstitutional. And so, just pardon a brief digression, I think given that posture, the particular facts of the case shouldn't make that much of a difference. But if you were Elizabeth Prelogger and you were trying to dream up bad facts for this case, this is what you would come up with, because Mr. Rahimi is not like a run-of-the-mill guy who beats his partner and wants to continue to possess firearms. He assaulted his girlfriend and fired a gun at the witness to the crime who was fleeing, then threatened another woman at gunpoint after his girlfriend got a restraining order, then fired an AR-15 into someone's home, and on 2 occasions shot at somebody on the road who cut him off in traffic. And when the cops investigating those crimes searched his house, they found 2 firearms and a bunch of ammunition sitting right next to a copy of the protective order signed by Mr. Rahimi, which said that he was not allowed to possess firearms.
Of course, all begs the question why the only thing he's subject to at this point is a protective order. But.
Which is the point that is made by Mr. Rahimi, as you would imagine. So turning away from those atmospherics to the legal issue, in Heller and Bruin, the court indicated that governments may disarm people who are not law-abiding and responsible citizens, and it won't surprise you that the federal government's merits brief quotes that language like a mantra 62 times, and says this statute sort of plainly falls within that carve-out. And Mr. Rahimi says, hold up, the Second Amendment affords a right to the people, including people like me, and if you want to disarm me, then you have to point to a relevant historical tradition. And I do think that the court is going to want to look at history here, and that will bring it to an interesting methodological question that lower courts have been wrestling with across the country, which is, when you're looking at a historical tradition, at what level of generality do you define the tradition? And Bruin said you're not required to establish a historical twin or a dead ringer. The federal government here points to a bunch of statutes from the 18th and 19th century where governments have disarmed certain categories of people in certain circumstances. The Fifth Circuit, took a close look at those examples and said those are not a close enough fit. For a variety of reasons, they are distinguishable. Now, in fairness to the federal government, this is an area where, sadly, throughout history, governments did not really prosecute domestic violence, and restraining orders are sort of a new thing. So it is hard to find those spot-on analogies. I think for a variety of reasons, it seems like the government will have a fighting chance here, and the court's analysis will probably have to shed some more light on this analogical inquiry, although my hunch is that some members of the court at least are going to be looking for a sort of narrow ground for ruling here that's not going to answer all of the open questions that are being litigated in the lower courts. And then the last case I'll preview is one that was argued just yesterday morning about the CFPB statutory funding scheme and whether it violates the appropriations clause. So the funding scheme is unusual. It allows the director of the agency to decide each year how much money the agency needs up to a cap, which is about $750 million now, and then unspent funds roll over. And this case arose out of a challenge to the 2017 payday lending rule. The appropriations clause theory was so central to the plaintiff's challenge that they devoted not 1 but 2 pages to it in their appellate brief in the Fifth Circuit. And the Fifth Circuit said that the rule was sort of fine on the merits, but then vacated the rule on the ground that the funding structure violates the appropriations clause. This is one of those cases where both sides have challenges in terms of limiting principles for their position, and you saw that play out in the argument yesterday. So the federal government's position is that the appropriations clause gives broad discretion to Congress. It doesn't have to pass an annual appropriation, doesn't have to be for a fixed sum, and Congress has historically done a lot of different things. And that leads to the question of, well, okay, but could Congress authorize the president to spend up to $1 quadrillion each year in perpetuity? General Preliger said no, but was pointing mainly to political checks and sort of, well, at the outer limits, perhaps there could be a constitutional check, and we'll see how satisfying that answer is to the court. On the other hand, the plaintiffs argue, look, this isn't really an appropriation at all. This spending cap is illusory because the agency has never actually hit the cap. And so, in effect, it's like a blank check for the agency. The tough questions that they get are, well, there's a lot of other agencies that have similar funding schemes, including a number in the financial regulatory space. So are you asking us to adopt a rule that's going to strike down all of those funding schemes as well? There are also some interesting questions as to remedy and severability. And so this is a case where even if the court holds that there is a constitutional violation, it's possible that they could craft a remedy that would not sort of broadly destroy the work of the CFPB over the last 12 years or so. So I will turn it over to you, Easha.
So I'll also just be really quick and just flag for you guys that there's another interesting social media case, a pair of cases up at the court. In full disclosure, the Stanford Clinic is involved on behalf of the plaintiffs in one of these cases. So the defendants in the case that we're involved in are elected members of the Poway Unified School District Board of Trustees. And they use social media pages, kind of branded their official pages, featuring their school district email addresses, highlighting the kind of seal of the school district. They use these pages to kind of inform their constituents about what's going on in the school district and also to kind of solicit input. And so the question in this case is whether in using these official pages to do part of their work, they're engaged in state action. And this matters because if they are, then they're bound by the Constitution. So this case is specifically about the First Amendment. They blocked our clients who were trying to complain about financial mismanagement in the district and about kind of racism against their child in the district. They blocked our clients based on the content of their communications, the content of the comments. So First Amendment challenge. But if these elected officials are not engaged in state action, that means there's no constitutional constraint, right? They could, in theory, block all Black constituents in the 14th Amendment would have nothing to say. So the stakes of this case are high, not only for the First Amendment piece of the puzzle, which as more and more speech kind of takes place online and kind of core kind of democracy-enhancing functions happen over Facebook and X and whatever other social media platforms, but also for the other amendments that can come into play. And our position is sort of the tools of the Constitution are sufficient to handle this. That is, you don't have to worry if you say there's a constitutional constraint there. The First Amendment still gives you the tools that you need to block the trolls or the death threats or the spam. So I think that's sort of another kind of interesting case that tees up the sort of free speech, social media intersection that Erin was talking about.
And I'm just going to briefly talk about Loper Bright, but then we're going to take questions. So if people have questions and want to start moving toward microphones, you're welcome to do so. But as many of you may know, the court has taken up the question of whether to overrule the Chevron doctrine. That this is the doctrine that says that if a statute is ambiguous, the courts will defer to the reasonable interpretation of an agency that administers the statute. The court, over the years, we've seen this court even before some of the newer membership for a while, I think the Roberts Court has been pretty skeptical of the administrative state, pretty hostile toward kind of broad conceptions of executive power, of aggrandizement of agencies. And this feels like, it could be kind of a culmination of some of that. And this is another area where the court has had lots of opportunities to weigh in. It's had lots of petitions asking if it wanted to overrule Chevron, and it denied a lot of them for a long time. And frankly, we were a little surprised when they granted ours, because they had been sitting on that one for several weeks as well. But the court not only granted the petition, but did something that really signals that they are interested in actually cutting back on or even overruling Chevron. As is common in these cases, we had 2 questions presented, one of which was about overruling Chevron, but the first question was simply like, did the lower court interpret this statute wrong? And I won't go into the details of the statute, but there's a pretty strong argument that they got the statute wrong. And the court made a point of not granting cert on our first question about whether the lower court got the statute wrong. The only question they granted cert on is our question about whether to overrule or at least narrow the Chevron doctrine. So I do think this, there's been a lot of cases over the years where there's lots and lots of briefing about Chevron and people asking the court to overrule it in amicus briefs and all of these things, all for the court to end up saying literally not a word about Chevron in its opinions. That seems relatively unlikely here. So definitely a really important administrative law case to watch.
You guys want to ask questions? Both of the mics are on, so just feel free to queue behind one of the microphones and start on the side.
Okay, so I have a question about 303 Creative. It seems like kind of leading up to that case, it was fairly clear where the Supreme Court was. Okay, I can grab the microphone. Okay. It was fairly clear where the Supreme Court was going with the case, given the facts of the case, the stipulations, and the argument. So I was wondering what your thoughts were on these cases, gay rights cases, abortion cases, where you have the justices having taken certain positions already, and you have cases where you may have just a local ordinance that could be amended or somehow or rescinded with one county, one city, and just carve out to try to moot out that case. And just if you see that as a strategy, kind of an increasing strategy going forward in certain cases, particularly with state government, local government, and what your thoughts were on that.
You mean in the sense of local governments kind of trying to moot them out when they see they're about to get to the Supreme Court?
Exactly, and kind of taking a more kind of aggressive role in looking at the merits of the case and where it's going in the national impact too.
You don't have any personal experience with that, do you, Erin?
It's the new Second Amendment. But I think, look, if you've been following the court's jurisprudence in this area for a while, I think this really goes back to what even Justice Kennedy said back when the court recognized a constitutional right to same-sex marriage, which is the court it seems to want to draw a difficult and sort of tenuous but important distinction between, like, we're going to recognize rights, but at the same time we're not going to override religious views. And that's hard. It's easy in theory and hard in practice, and I think that's at the core of a lot of these cases. I think, frankly, with this court, in a lot of cases, you ought to see the writing on the wall. And so if I were, advising a state or municipality, I wouldn't encourage them to push this envelope right now. I don't think this is the right court to get really aggressive with your laws. And part of the reason Colorado, that these cases happen is because Colorado has a particularly aggressive public accommodations law. So, whether we'll see that mooting, we'll see, and how the court will react, we'll see. They had an argument today in which there was a lot of discussion about, strategic mooting, and maybe we'll get some insight soon into what the court thinks about those kind of tactics.
I'm just taking notes over here. I don't have anything to add.
All right, thanks. This was great. So I want to reignite the debate between Easha and Erin. You guys weren't quite putting it in these terms, but one of the issues in resolving whether universities can figure out a way to preserve the status quo in a way that's consistent with the opinion is whether or not efforts to do that in order to preserve the status quo would be consistent with the Constitution. this is one of the things that's always been kind of odd to me about equal protection law, is that things like the 10% plan were treated as race neutral, even with an acknowledgement that they were passed because of an effort to entrench effectively an affirmative action outcome. And so I'm curious whether the tea leaves are clear enough at this point to have a sense of where the court might go on that.
Yeah, so one note for the audience is that there is a case kind of hurtling toward the court. It's about Thomas Jefferson, which is a magnet school in Virginia, that did sort of exactly what you're describing. So they are concerned because of the demographics of their class, and they say we're going to adopt a new plan that decreases reliance on standardized testing, that gives each middle school sort of a priority, making sure we have students for every middle school. But as you know, the kind of stated goal is kind of an end goal that has to do with race. And I guess so tea leaves on that. I think am I right? 3 justices would have, yeah. So I think 3 justices have signaled, at least at the stay stage, sympathy to the challengers in that case. So we've got 3 justices on board for exactly the theory you're articulating, which is that the goal of racial diversity is in and of itself suspect in some way, or sort of taints the process, even if the means you're using to achieve that are race neutral. In terms of tea leaves, I suppose I'd say 2 things. The first is I want to be clear that when I'm saying that universities might wind up in the same place, I mean that not necessarily or not wholly because they're going to engage in some sort of, I have this goal of getting a class that looks like this, and I'm going to figure out a way to look at the essays and get there. I mean that genuinely, that if universities are right, that actually for the vast majority of their applicants, race is intertwined with their experience and in precisely the way the chief allows, then you would expect pretty similar results, right? You don't have to say, I want a class with exactly these demographics, if universities have been right all along, that actually when you look at the essays of these students, you're going to wind up with sort of a roughly similar configuration. So I want to just make clear that the kind of premise of my hypothetical of inviting litigation classes look similar is not necessarily because universities are going to come out and say, we want to figure out a way to engineer classes looking similar. So that's point 1. And then on the kind of tea leaves point of where the court will go with this, you know, I'm not sure how eager they are to do this anytime soon, right? I don't know what it means. You know, the 3 of the justices noted their dissent. But given the kind of tenor of the argument in the affirmative action case, the fairly kind of categorical rejection of the kind of historical evidence around the time of the second founding, right? That many of the justices seem skeptical of the idea that any kind of race consciousness was part of that history. I think that, you know, I think if the court decides to wade into this, I think the challengers to the Thomas Jefferson plan have a decent chance of victory if we're just looking at tea leaves. I'm curious if you agree with that.
Yeah, you know, I mean, I guess I'm a little more skeptical. I think one thing that really can't be overlooked in the court's opinion is the discussion of the fundamental flaws in even thinking about the demographics. I mean, there's some really powerful discussion in there of kind of the arbitrary way in which students are categorized as, you know, Asian, or, you know, like you count as Hispanic if you're from Spain but not Portugal, or vice versa, or just things that don't even seem to really make sense. And given that that was an important component of how the court was thinking about this being a problem, I do think that the whole majority of the court would be rather suspicious of a program that kind of produces the same results when one of their problems was the results themselves are rather arbitrary and don't necessarily across all categories even map onto what are sort of sensible ways to think about different racial demographics. So I agree that the court may not be anxious to dive back into this right now, and they clearly kind of didn't want to go all the way to saying thinking about racial diversity is something that's a problem. But I do think the mood music from the 6 and all 6 here is, look, if you are coming at it from, you know, the ultimate objective being we want to accomplish a sort of, you know, where we started, or we think we can kind of sort of get to the same place through, like, kind of exactly the same place through different means, there's going to be a lot of suspicion of that.
And maybe one final follow-on on this point is, I think that's right with kind of one exception, which is that both at argument and in Justice Gorsuch's separate writing, you see a lot of the court being very concerned about the fact that they see this as kind of a problem of the university's own making, right? So Justice Gorsuch has this line, I'm going to get the statistics wrong, but he basically says if you like got rid of the bonus for kids of faculty members and you halved the bonus for recruited athletes and, you know, whatever, reduce the bonus for legacies to some extent, you'd actually wind up with exactly the same class. Now, I don't mean to say that he's suggesting like universities should do that to achieve diversity aims, but I do take some of the undertones of both the argument and the opinion in this case to basically be like, look, the only reason you have to consider race on the back end is because you've boxed yourself in by giving away huge chunks of the class to people in these various categories. So I don't know what that winds up looking like, and maybe if there's sort of an express, we're getting rid of legacy admissions to achieve a sort of racial balancing effect. Maybe that looks, you know, as Erin said, maybe the majority looks really skeptical. But one thing I think I heard an argument, and that I see in at least Justice Gorsuch writing is I think would be some sympathy for the notion that like maybe a way that you achieve a class that that accomplishes the kind of racial diversity ends you have looks like getting rid of what the court perceives as kind of these unfair tips.
Yeah, the only thing I would add is that, you know, there are case studies here. This is referenced by Justice Sotomayor in dissent. And for those folks who are interested in kind of practically what does this look like in the future, I mean, we're in a state where, as a matter of state law, affirmative action has not been allowed in university admissions for quite some time. And I would commend to you the amicus briefs that the regents of the University of California have filed, not just in this case, but in prior cases, that talk about their experiences and successes and challenges in this area, because it's not as if there are not case studies in California and in a few other states that have those types of bans.
Yeah, and I actually think the majority viewed that as helpful to their cause too. I mean, both sides were viewing those experiences because there's been positives and negatives, as you say, and I think, you know, I think there's an appreciation. I mean, it all comes down to the debate about what diversity means, and I think the majority of the court believes in accomplishing diversity, but they don't necessarily see that through quite the same racial lens, and I think that's really the rub of it. But that's not really what they directly say in the opinion.
All right, thank you. Thank you all for your comments today. I had a question that was sort of similar to the previous one about 303, but slightly different, maybe best suited for Mike. I was curious how you read the impact of 303 on other states' anti-discrimination laws. I know that Colorado had a particularly robust scheme, but you know, to the extent you've thought about it in California or in other states, will public accommodation laws, anti-discrimination laws in general, it's not like 303 struck them down, but it seems like they might be limited. And so as a practical matter, how can states and localities enforce them with this new caveat that 303 has carved out?
Yeah, I'm not sure that I have the most satisfying answer, and I think that's in part because of this dynamic that Erin described, which is because the majority opinion is so focused on the stipulations within the Colorado court record. To me, at least, and maybe I'm I think it does leave a lot of questions unclear and left to be litigated. And I think all I can say is that, you know, I think states across the country are very mindful of these cases and of the dynamic and the composition of the current court, and wanting to, as always, comply with our constitutional obligations. You know, from my standpoint, and I'd be interested in Erin's perspective on this, because of the stipulations there. This was a case that was sort of all about the hypotheticals and the line drawing exercise. And there were a lot that came up at oral argument and that are pointed to by the dissent. And I'm still not totally clear what the majority wants to do on some of these tough hypotheticals. I mean, to Erin's point, this was somebody who had a sincere religious belief, but the majority does not found its holding on that. And so in the next case, if it's someone who just says, I don't have a religious belief, I have a sort of racist belief that I don't believe that these two people should be married, how do you analyze that? And I think that there are certainly aspects of the majority's opinion that could be construed as saying, well, you know, that has to be respected as well. And I suspect there's going to be a lot of litigation and a lot of hard thinking in state and local government agencies about how to come at that issue as well.
I'll just offer the final thought. Like, I'm not sure I really think like the court was specifically focused on people who are in the business of speech. And I don't think that the opinion is designed to or does open the door to people who are in other businesses to just come in and say, well, in order for me to comply with the law, I have to engage in some speech. I mean, the court rejected that argument a long time ago, that having to take down the sign that says no blacks allowed doesn't violate the First Amendment, because that speech is incidental to a regulation of conduct. And so if all you're complaining about is speech that's incidental to a regulation of conduct, and your business is conduct that doesn't involve speech, I really don't think this case has huge implications. What it has implications for is the businesses that are able to argue that what they are doing at their core is providing the service of expressive services or speech.
Well, we've come to the end of our time. I'd like to invite everyone here to a reception, which will be outside, and our speakers will be there, so you'll have a chance to engage with them some more. I also would like to mention the next program of the Constitutional Law Center, which is next Monday. Professor Mark Tushnet from Harvard Law School will be speaking, and it's going to be on the topic of craft versus judicial craft versus legal interpretive theory. So this is, I think, going to be a particularly interesting question for people who think about how courts go about their work. So he is one of the nation's most prominent constitutional theorists, and always an interesting guy. So I encourage you all to come, and to come to the reception, but most of all, to join me in thanking our speakers for such a stimulating discussion.
Thank you.